Hi class. So for today's lecture we're going to be talking about both the criminal justice system and the civil justice system in our country and overall how the court system works. So first let's touch on criminal courts. Criminal courts are going to be, probably the most familiar to you, and they're typically what you envision when we talk about court. We see it on TV and in society. But they're actually much less common than media or news would make it out to be. And there are some unique things about our criminal justice system in our country. And one of those things is that we have what is called an adversarial system. And this is based on English common law. And you're probably very familiar with this type of system. Essentially what it is it's one side against another. So we have the prosecution and the defense, and they fight it out, and then we come to a verdict. But this is in comparison to what's known as an inquisitorial system. And while in England they use an adversarial system, much of the rest of Europe, as well as some Asian countries, use what's known as the inquisitorial system. And this is very different. In this type of system, there's not really two sides. There's really just a person who makes the decision, and this person could be a judge or a panel of judges. And one thing that happens in this type of inquisitorial system is that it assumes that every witness that comes to the court is just going to be completely neutral. And so all they are doing is they are providing the court with information, and this information is meant to inform the judge. So expert witnesses in the inquisitorial system are actually not for one side or the other, so it's not the defense's expert or the prosecutor's expert. Expert witnesses are going to be called by the court itself. And another main difference here with the inquisitorial system is that in an inquisitorial system, you are presumed guilty until you are proven innocent. So essentially, there has to be enough evidence to try to prove that the state made a mistake. And this is completely opposite of the adversarial system that we see in the US, where you're presumed innocent until proven guilty. Going back quickly just to touch on the adversarial system, so it really is this idea that there are two versions of the truth that are being presented, and we have the fact finders who are left to sort this out. And in the adversarial system in the US, those fact finders are going to be the jury. And essentially they're going to listen to both sides, and then they're going to determine a verdict. So now I just wanted to touch on some comparisons with the English system. So while our adversarial system did come out of English common law, there are some similarities, but there are also some very big differences between the US system and the English system. And one of those differences is that there's really two types of courts in the English system. And another difference is that there's two types of attorneys in the English system as well, and those attorneys are known as solicitors and barristers. So solicitors are the attorneys that are going to work on lower level issue cases. So you're going to see solicitors in what's known as the magistrates court, and that's the lower level court in the English system. And those would be issues such as wills, divorces, contract law. And in comparison, we have the barristers in the English system as well, and those are going to be the attorneys that we see in the higher courts. And the higher court in the English system is known as the English Crown Court. And this is very different than the lower courts, so we're going to just play a quick video here to show you some of the differences that we can see between these two types of courts.
I am the judge, and it's my job to interpret and uphold the law. Other people present during a trial at the Crown Court are the prosecution barrister and the defence barrister, usually with solicitors behind them taking notes. and the jury. The defendant will sit in the dock and be present during the trial. It is at my discretion whether or not there is a public gallery. After the jury has been sworn in, I address them directly. I inform them that it is for them to decide if the evidence they are going to hear proves the defendant's guilt. I also inform them that it is their job to consider the evidence, not the law, and that I will guide them if necessary on points of law.
I am the next person to address the jury. I introduce myself and explain that I appear on behalf of the prosecution in this case, and my learned friend, who I name, appears on behalf of the defense. I then outline the prosecution case, explaining each offense and the evidence the jury will hear in proving this. I will state that it is the prosecution's responsibility to prove beyond any reasonable doubt that the defendant is guilty of the offense that they are before the court for. I will introduce the first prosecution witness. I will then ask a series of questions with regards to the evidence they have given in a statement to the police. This is known as examination in chief. Upon completion of this, the defense may ask the witness a series of questions. This is known as cross-examination. Upon completion of the cross-examination, I may be given the opportunity to ask a further series of questions to the witness. This is known as re-examination. I will continue to call witnesses until all the witnesses have been called to the stand. I will announce to the court that this is the case for the prosecution.
At this point in the case, I may make an application of no case to answer to the judge, stating that the prosecution has not raised sufficient evidence to prove that the defendant has committed the alleged offence. If he finds in favour of my application, he will instruct the jury to find the defendant not guilty, and then he will release the defendant. This is an acquittal. If the judge considers the prosecution has raised enough evidence, then I will continue with my case. As with the prosecution barrister, I will introduce the witnesses. However, at this time, they will be giving evidence for the defence. This will follow in the same procedure of examination in chief, cross-examination, and then re-examination. At the end, I will declare that was the case for the defence.
I then stand and give what is called my closing speech, where I outline the prosecution case and try to persuade the jury that the defendant is in fact guilty.
I then stand and give my closing speech, outlining the defence's case and trying to persuade the jury that the defendant is not guilty.
I will then sum up all the evidence. I will direct the jury on the legal issues and what the prosecution has to prove if they are to find the defendant guilty. I will give them the legal options available, reminding them that if they are not sure, they must find the defendant not guilty.
We then retire to make our decision. Once a decision has been reached, we return, and as foreperson of the jury, I announce the jury's verdict. If found not guilty, the defendant is released.
If the defendant is found guilty, I will make a statement in mitigation to the judge. The judge will take this statement into account before sentencing.
I thank the jury for the service that they have provided. If the defendant is found not guilty, I will release the jury from the court. If the defendant is found guilty, I will move to sentence him in a straightforward case. It is likely in that instance that the jury will remain in court. I may, however, postpone sentencing where other factors are to be considered. This can be particularly appropriate where there have been contentious issues or where the defendant's background is likely to have a significant impact on the sentence I pass.
So as you can see there are a lot of similarities between our system and the English Crown Court, but there's also a lot of inconsistencies. So for example, the standard of proof beyond the reasonable doubt was the same, similar to us, but you can also see that it's a much more formal procedure with the robes and the traditional white wigs. Okay, so now let's compare what we just saw in terms of the English Crown Court and compare that to the lower level court, which is the magistrate's court. And I apologize if the quality is going to be a little rough at the beginning, but it'll get better within a minute.
We are the magistrates. We hear all the evidence in the case and decide whether the defendant is guilty or not guilty. It's for the prosecution to prove their case beyond all reasonable doubt, otherwise we will dismiss it. Traditionally, there are 3 magistrates. I am the chair and will decide the case with my 2 colleagues. If my 2 colleagues can't agree, I will have the deciding vote. Occasionally, we may have to sit as a pair and then decide the case between us. Although we've had some training, we are not legal professionals and we are not paid.
Magistrates hear all summary offences within their jurisdiction. We can also hear triable either way offences where the defendant has agreed that this can be the case. If we believe that a trial is too serious, we can refer that case up to the Crown Court. Even after we've heard a case, we can refer that case to the Crown Court if we believe that our sentencing powers are not sufficient.
I am the legal advisor to the justices, although you may still hear me referred to as the clerk of the court or the magistrate's clerk, and I am legally trained. My job is to ensure that everything runs properly and that all the proper procedures are followed. I will ask a defendant to enter a plea, and I will ask witnesses to identify themselves. I will advise the magistrates on legal matters, and I will ensure that only admissible evidence is put before the court. If a defendant is unrepresented, I will advise them to ensure they get a fair trial.
I am the usher. I ensure that all witnesses have answered their summons. I'll fetch witnesses in when they're called and administer the oath or affirmation. When the witness is giving evidence, I will pass exhibits around the court. I can even fetch a glass of water for someone if they're thirsty. You will hear me say, "All rise."
I'm the prosecuting solicitor and I present the prosecution case. There are 3 things that I must prove to the satisfaction of the court. Firstly, that an offence has been committed. Secondly, that the defendant has committed the offence. And lastly, that all the evidence has been gathered in accordance with the correct evidence gathering procedures. If I fail to do any of those things, then the defendant is entitled to an acquittal. I will ask questions of prosecution witnesses to enable them to give evidence. I cannot ask leading questions or suggest answers. Obviously, I can only present evidence that has been gathered fairly. If there is a case to answer, and the defence call witnesses, then I can cross-examine those witnesses. Remember that prosecutors are only as good as the evidence they are given.
I am the defence solicitor, and it's my role to protect the interests of my client. I can challenge evidence that has not been gathered fairly in accordance with the Police and Criminal Evidence Act of 1984, and have that evidence excluded if so required. If you have been fair, thorough, exercised your powers correctly, and can account adequately for all your actions, then there should be little for me to challenge. Remember.
Okay. So as you can see, the magistrate's court there is quite different than what we saw in the English Crown Court. For one, there's solicitors as attorneys instead of barristers, and it's less formal. But the most important difference there, as you can see, is that there's no jury system in the magistrate's court. It's really only 3 people who are not legally trained that are up to make this decision. So in that way, it's kind of a little bit more like inquisitorial system. And then finally, I just wanted to touch on a couple more differences here. One interesting thing about the English system is that attorneys aren't separated out as strictly defense or prosecuting attorneys. What happens is barristers will put their names into a pool And essentially, attorneys can play very different roles in very different cases. So they can serve as a defense attorney in one case while also serving as a prosecuting attorney in their next case. And it's expected of these attorneys essentially to say yes, either to defense or prosecution, if they have the time and if they are available. And another big difference between the English system and the US system is that in England, police initiate prosecution. So this is very different. Whereas in the US, the DA will decide if we're going to take a case to prosecution. And police in the US put a lot of work in to get it to that point, and then sometimes the DA decides not to prosecute. However, in the English system, the police are the ones themselves that will initiate the prosecution. So that just gives you an overview about how it's different in the US versus a system like England. Going back more to the US and what crime really means in the US, one really important thing to understand is that crime is really an offense against the state. So most of us think about crime as being against a person, a victim is hurt or somebody is victimized. But when we really think about crime in our system, the person is committing an act that is against the state. So that's why we have cases that say something like State of Wyoming versus Aaron James McKinney. He was one of the defendants in the Matthew Shepard murder. So in our criminal justice system, the victim kind of goes away. And we'll talk about this a little bit later on into the semester. But yeah, as you can see, the victim isn't even named in the criminal case. So really all crimes are against the state, or if it's a federal crime, then it'll be a crime against the federal government. But they're really not considered crimes against the victim. And then lastly, it's important to understand that because of this, only the state can punish. So really crime is this behavior that happens because somebody violated this state statute, and the state is the one that can punish them. Next, I wanted to just talk about civil courts. So civil courts are probably, you think about them a lot less when you think about court, but they're actually much more common than criminal court cases in our country. So what a civil case is it really is just a dispute between two individuals. So one person is suing another person. So this isn't going to be Cassie Flick versus State of Wyoming. It would be Cassie Flick versus John Smith. And as I mentioned, civil cases really do far outnumber criminal cases in our country. You can see some numbers here, statistics from 2018, 277,000 versus 81,000. So they really are much more common, and they're the most common type of case in this country. So what about some differences between the civil justice system and the criminal justice system in our country? So first of all, if you want to sue someone, you have to have standing. So the litigant is the person who is suing. They must have standing. And what does standing mean? Standing really means that you must have personally suffered because of someone else's behavior. So for example, say there were certain cigarette companies that, because of their advertising, I thought that it was putting children in harm's way. I thought that they were advertising to youth in the way that they shouldn't be. And I wanted to sue the company about their advertising practices. I would not be allowed to do this because I haven't been personally affected. So it can't just be something that you think is outrageous or morally wrong. You have to be, as the litigant, personally affected or have personally suffered from someone else's actions or behavior. Another big difference is the standard of proof. The standard of proof is much lower in the civil justice system. In the civil justice system, you only have to have a preponderance of the evidence. And preponderance of the evidence really just means it's more likely than not that this happened. So it's simply kind of like a 51% cutoff mark there. So that's a much lower bar than what we see in criminal court, which is beyond a reasonable doubt. And lastly, due process is not as exhaustive in the civil justice system. You do not have the right to an attorney in the same way, and because of this, we often see things where litigants with deeper pockets, who might be able to afford attorneys or more attorneys or better attorneys, can often win. So let's quickly just go over what happens when somebody files a civil suit, because this is a more complex process that is not portrayed as much in the media or other sources of information. So first of all, we have in a civil suit, we have a plaintiff versus a defendant. So rather than the state or the prosecution, we have the plaintiff. So the plaintiff is the person who initiated the suit, and then the defendant is the person that is being sued. So first, the plaintiff files a complaint with the proper court, and this can actually be a little bit harder to figure out. So you have to figure out within your city which is the proper court to receive your complaint. And then the court will determine the jurisdiction and the venue of this complaint and where this complaint can be heard. And obviously, for some cases, this isn't a big issue. So if I had a tenant complaint against my landlord in Laramie, this complaint would be held in Laramie, but it gets a little bit trickier when you think about things like class action lawsuits, where there's a lot of plaintiffs suing one defendant. An example of this would be years ago, we had in this country class action lawsuits against tobacco companies. And really, the tobacco company, as the defendant, was trying really hard to have this case heard in certain areas of the country. You know, basically to have this case heard in tobacco country, so places like North Carolina, South Carolina, Kentucky. So they're really looking for a certain type of juror in that case. So for class action lawsuits, the venue can be a really big deal for wanting to find specific type of jurors and people for the jury pool. And then lastly, the summons is going to be served to the defendant. And overall, this, although we just broke it down into a couple quick steps here, it really is a much more complex process, and it's very different than what we see in criminal court cases in the US. Next, I just wanted to touch on the US Courts of Appeals. So we have an appealing process in this country where you have the opportunity to appeal a case in both criminal and civil court. And as you can see here, our courts of appeals are divided up into 13 different courts. And the first 11 take care of all the states here, and then we see DC, which obviously isn't a state, has its own, and then the federal government as well. So you can see here that Wyoming falls into the 10th District Court of Appeals. So this means that along with Wyoming, any of these other states, such as Colorado, any of these states here, when they appeal a case, it'll go to the 10th District Court. And one important thing is to realize is that these 13 courts don't always agree. So they can go different ways. And when there is that difference of opinion, that conflict between these courts, that's when that case would go all the way up to the Supreme Court. But another really important thing to note here is that when a case gets decided in a district court, it applies to all of the states that are underneath that district. So for example, we have Utah here in the 10th district, same as Wyoming. So Utah had a same-sex marriage case that went to the 10th District Court of Appeals. And in that case, the court decided that same-sex marriage is legal. So then automatically, it became legal in all of these other states that the 10th District presided over, including Wyoming. And finally, I just wanted to touch on, we've talked about criminal courts and civil courts and the Court of Appeals. I just wanted to touch on a few other types of courts very quickly that we do see in the U.S., and that's going to be family or juvenile courts and domestic relations courts. So in the juvenile or family court, some of these, depending on the state, they might be combined or separated out, but really the purpose is to protect children and preserve families. So this court doesn't really punish people, and they don't have to have had committed a crime to go to this court. It's more of a civil process. And this process is initiated by social services, so maybe Department of Family Services, and they might be initiating a case due to reports of child abuse. Or perhaps something that would go to this court is if a juvenile commits a crime. And really, the main purpose in the juvenile or family court is rehabilitation, and that's really what these courts are focusing on. And then lastly, we have the domestic relations court. And in domestic relations court, you deal with things such as divorce or child custody. And these types of cases are initiated by parents. And there's also very few due process rights in the domestic relations court. So if a parent wants to have an attorney, then they have to hire their own attorney. And this court really has very little enforcement power. They don't have the power of the police or really social services or other agencies behind them. And here are just some links from today's lecture if you want to access those YouTube videos. And then I provided a link to some of those 2018 statistics that I was mentioning. And there's some more stats on there if you want to go look at that as well. So next time, we're going to be talking about our judicial system and looking at judges and how judges interact with the system. So thanks for listening, and I'll see you guys next time.